Good afternoon. My name is Jim Townsend, and I am the director of the Levin Center at Wayne Law. I want to welcome you to today's presentation by Professor Emily Berman of the University of Houston Law Center, who is the winner of the inaugural Levin Center Award for Excellence in Oversight Research. Professor Berman will be speaking about her article entitled Weaponizing the Office of Legal Counsel, which appeared in the Boston College Law Review. In a moment, I will introduce Professor Berman. But before I do that, I wanted to mention the importance of Professor Berman's work and that of a growing number of other scholars who are doing research to strengthen the quality and effectiveness of oversight by Congress. The Levin Center is dedicated to advancing bipartisan, fact-based legislative oversight as an essential instrument of our democracy. There is a great deal we have to learn about how oversight functions, how it can be done better, and critical constitutional and legal issues raised by the inevitable conflicts that arise when Congress seeks to hold the executive branch accountable. The Levin Center set up the Award for Excellence in Oversight Research to encourage high-quality oversight research. Professor Berman is the inaugural award winner, but she overcame some stiff competition. Her outstanding article beat out a number of other very high-quality submissions. Her paper, as well as many others, are on the Levin Center website, and we invite you to take a look and send us others that should be added. I also want to mention that the Levin Center sponsors a website, oversightcases.org, that tracks about a dozen court cases relating to Congress's ability to conduct oversight, especially over the executive branch. Professor Berman's paper spotlights a key issue in those cases: how the executive branch has been using the Office of Legal Counsel to help itself prevail over Congress in the courts and in the court of public opinion. It is very important for the oversight community to be aware of what's going on and to think about how Congress ought to respond. We hope to get into those issues in our conversation today. Now, we have about an hour. Professor Berman will speak for roughly 30 minutes, and then we will open it up for questions. All of you are encouraged to submit questions via our chat function. I will do my best to get to as many of those as possible. Please know that this session is being recorded and will be posted on the Levin Center's website shortly after we're done. Now, just a few words about our esteemed presenter. Professor Emily Berman is an associate professor of law at the University of Houston Law Center. She received her BA from Duke University and her JD and LLM from New York University School of Law. Professor Berman's scholarship examines the unique separation of powers challenges that arise in the constitutional, statutory, and regulatory regimes governing national security policy. In particular, she focuses on ways to impose traditional conceptions of government oversight on law enforcement and intelligence operations. Professor Berman teaches national security law, foreign affairs law, and constitutional law, and her work has been published in top journals, and her opinion pieces have appeared in JustSecurity, The Atlantic Online, the National Law Journal, Legal Times Online, and CNN.com. And with that, please welcome Professor Emily Berman. Emily, take it away.
Thanks so much, Jim, for your kind introduction. I'd also like to thank the Levin Center for recognizing my work and providing this forum, and in particular, Jim and his colleague, Elise Bean, and as well as the many others who have provided thoughtful comments and critiques while I was working on this project. So let me quickly share my screen here. So hopefully everyone is seeing that. So the idea for this paper came to me shortly after the Mueller report was made public. In the wake of that report, on the one hand, you had the report itself noting that the Justice Department's opinion barring prosecution of a sitting president meant that DOJ would refrain from reaching any conclusion as to whether any particular presidential action was unlawful, or at least the special counsel would refrain. On the other hand, you had people then pointing to the Mueller report's failure to identify a crime as evidence that the president had actually been vindicated. So it seemed to be this sort of feedback loop using the Office of Legal Counsel's opinion about indicting sitting presidents that was then being used to justify treating the president as if he'd been exonerated. So that got me thinking about the impact that the Justice Department Office of Legal Counsel opinions can have on the political landscape and on public debates. And the more I thought about it, the more convinced I became that this was really an under-examined phenomenon, and that it was highly relevant, particularly in the context of disputes between Congress and the executive branch over access to information. So this paper is really an effort to think through that phenomenon, how does it work, and what might we be able to do about it if we see it as a problem, which I do. So just to start with the Office of Legal Counsel, most of what the Office of Legal Counsel does is relevant inside the executive branch. It focuses on what the law is with respect to questions that arise internally in the executive branch. And so most of the scholarship and analysis of the Office of Legal Counsel focuses on the ways in which it establishes and dictates the executive's position on various legal issues. And in particular, there's a robust debate about whether and to what extent the office actually imposes meaningful limits on executive power. And that's a very interesting and important ongoing debate. But my paper looks at sort of a different aspect of OLC opinions that tends to get a lot less attention. And this is their impact outside the executive branch, where actors are not necessarily bound by their conclusions, but they nonetheless have an impact. And specifically, my thesis is that when it comes to interbranch conflicts over congressional oversight of executive branch activities, OLC opinions don't merely provide legal guidance to executive branch actors, but actually influence the outcomes of those conflicts. And more specifically, the argument is that they place a thumb on the scale in the executive's favor, making it harder for Congress to engage in its desired oversight activities. Just as a preliminary caveat, I'm not arguing that OLC opinions are always dispositive. There are, of course, many factors that go into determining how information disputes between the branches are resolved. But I am arguing that this is one tool that the executive branch has at its disposal that has, in my view, not received the attention that it deserves to date. So my argument has three parts to it. The first focuses on the nature of congressional executive oversight battles. And it basically argues that the key to understanding how these battles are waged and resolved is to recognize that they are political in nature, just like any other political debate that goes on in the public sphere. The second part of the paper turns to the OLC memos themselves, first pointing out systemic reasons why the substance of the memos are going to favor executive branch interests over those of Congress, and then explaining how those members give the executive branch a political advantage over Congress. And then finally, I turn to possible reforms, and I argue that remedies that can sort of level this playing field are in order. And I have a few suggestions, none of them perfect, of course, regarding what some of those reforms might look like. So let's start with the nature of congressional executive oversight disputes. The Supreme Court and the executive branch have both recognized that Congress has broad authority under the Constitution to engage in oversight investigations of the executive branch. But there are times, of course, when the executive branch seeks to withhold information that Congress deems relevant or even necessary to its oversight role. Usually, these conflicts are resolved through negotiation, in which the branches seek to maximize the pursuit of their own interests while conceding necessary ground to the other. And so The types of compromises that might be reached are things like Congress may agree to narrow the scope of its information request, or the executive might agree to share information, but only to a limited number of legislators. And that's usually how these disputes are resolved. But when these initial negotiation efforts fail, the dispute can escalate. And at that point, Congress might bring some of its other tools to bear, might threaten to withhold appropriations or delay confirmation votes, issue subpoenas or contempt citations to executive branch officials. And in fact, we've seen several congressional contempt citations during recent administrations. Attorneys General Bill Barr and Eric Holder both were subject to contempt resolutions, as was Trump's former White House counsel Don McGahn, among others. And in response to these subpoenas or contempt citations, the executive branch might make a formal assertion of executive privilege. And then ultimately, Congress might then sue to have their subpoena enforced. But unless and until one party resorts to the courts, a move that actually has been until recently quite rare, these disputes really remain political in nature. So what do I mean by that? When I characterize these disputes as political, it's that the outcome of these disputes, as well as the branch's decisions regarding whether and when to make concessions or to escalate conflict, is based at least in part on the political branch's available political capital and their willingness to expend it. So this means that public opinion, or the extent of public support for the position of one branch or the other, plays a significant role in determining the outcome of the dispute. So, for example, if Congress subpoenas the White House counsel to testify, but the public doesn't believe that the subpoena is warranted, maybe it's viewed as part of a fishing expedition, that will embolden the executive branch to refuse. And knowing that it lacks public support, Congress might then be reluctant to press that issue further. But despite the fact that these are really political in nature, interestingly, they are waged in the language of law and precedent, with each side advancing legal and historical arguments to support their position. So both the parties and the media tend to frame these interbranch disputes as, for example, whether Congress has a right to a particular piece of information, or whether the executive branch's invocation of executive privilege is legally defensible. So this public opinion that in turn influences the outcome of the disputes is formed in part and influenced in terms of who is viewed as complying with the law and who is flouting it. So the second part of the argument turns to the role that OLC memos themselves play in this sort of political tug of war. And before turning to the mechanisms through which they exert their influence, I want to say a word about the opinions themselves and how the office's separation of powers opinions systematically are going to set out pro-executive opinions. So as I mentioned at the beginning, the Office of Legal Counsel provides authoritative legal advice for executive branch officials. And as a tradition, its opinions are treated as binding unless they're overridden by the Attorney General or the President. And historically, the Office of Legal Counsel has enjoyed a reputation as a very principled, independent office, relatively insulated from partisan political forces. And it describes its duty as rendering candid, professional legal advice based on, quote, its best view of the law, rather than serving as an advocate seeking to justify executive policy preferences. And the office has institutionalized mechanisms designed to preserve and further that role. So for example, there's a strong presumption that the office is going to adhere to its own precedents across administrations. So even if the presidency changes from a person of one party to a person of the other party, the Office of Legal Counsel is not going to switch on a dime and adopt the views of the new president automatically. They're going to remain true to their own earlier precedents. Now, this reputation and legitimacy has periodically taken a hit. Notably in 2004, the memos that authorized the CIA's interrogation regime came from this office and were roundly criticized and led to a lot of rethinking of how that office functioned. And similar arguments have been made about some of the OLC opinions that have come out during the Trump administration. But the office seems to largely have recovered from the concerns in 2004, and assuming that it takes measures to sort of shore up its reputation now that the Trump administration has ended, I assume the same will happen going forward. But the one key issue is that when it comes to questions about the separation of powers and the relative entitlements and obligations of Congress and the executive, independent of political matters, it's not the same as impartiality. So being independent, as in nonpartisan, doesn't necessarily mean that you are impartial when it comes to the roles of the different branches. Part of OLC's mission is to assert and preserve executive prerogatives. And the office has recognized that the point at which Congress infringes on those prerogatives is often indeterminate. So by definition, there's a range of reasonable views about what Congress is entitled to as an oversight matter. And OLC is going to be on the pro-executive side of that spectrum. In addition, because these separation of powers disputes are usually resolved through negotiation, OLC's opinions can in some ways be viewed as sort of the starting point for negotiations with Congress. And so the lawyers in that office are really incentivized to take a relatively strong pro-executive position, which then provides sort of maximum room to maneuver in working out a resolution of the dispute. And then a last way that pro-executive positions seem to come out of OLC is that the office tends to memorialize, in not all of its advices in writing, it also gives oral advice, but the memos that it does write, and so the opinions that are sort of preserved for posterity, are all about what the executive can do. If the office reaches a conclusion that something that the executive branch wants to do is actually not lawful, it does not write an opinion memorializing that answer. So there's a large record of all the sort of yeses that the executive may do something, but none of the limits on executive power that the office has come across get memorialized in the same way. So, so for various reasons, OLC separation of powers opinions are naturally going to favor the pro-executive view. And I don't necessarily mean that as a critique. That is the role that this office plays, and maybe that's the appropriate role for that office. But because these opinions impact the political economy of information disputes in a way that doesn't take this pro-executive bias into account, it's important to examine how that operates. And again, my argument is that because the law, and maybe more importantly, the public's perception of the law are central to how these debates play out, there are several ways in which OLC memos give the executive branch a leg up in the court of public opinion. And so this is really the heart of my argument. And I identify about 4 mechanisms through which this comes to pass. So the first is that these memos give the executive branch a first mover advantage. The same issues tend to recur year after year. So our presidential advisor is immune from testifying before Congress. What is the scope of executive privilege? So often OLC can take an existing memo off the shelf and sort of update it quickly to deal with the facts of the dispute at hand, and in short order deliver a relatively sophisticated legal argument that's applicable to the ongoing dispute. And what this does, it has 2 effects, I think. So first, it allows the executive branch to really frame the terms of the debate according to its perspective of what's at stake. And then it also allows executive branch spokespeople and their surrogates to immediately converge on the same message. So in other words, the opinions can sort of act as pre-drafted talking points. So everyone is instantly on the same page, sending a unified message, and that message is, this is why the executive branch is in the right here. Secondly, the frame that is presented is usually not presented as an argument or as the executive branch's interpretation of the law, but rather as a definitive statement of the law and of historical practice. At the same time, because of the scarcity of judicial opinions on these information disputes, Supreme Court has not weighed in on most of these legal issues. And so the law really remains unsettled. So take an example of an executive branch official subpoenaed to testify before Congress. The official refuses at the president's instruction, asserting executive privilege as a justification. And in response, Congress holds that individual in criminal contempt of Congress. Now, the criminal contempt statute says that the Justice Department has the, quote, duty to bring contempt citations before the grand jury for possible indictment. So that's the language of the statute. Supreme Court has never addressed this question, so it's entirely up for debate whether such a prosecution would in fact violate the separation of powers. Yet OLC has concluded that it would, because it would impermissibly infringe on the president's ability to assert executive privilege. So that's their view. The Supreme Court has never said anything about it. Yet the OLC memo on the subject begins with a statement that, quote, a United States attorney is not required to refer a congressional contempt citation to a grand jury or otherwise to prosecute an executive branch official who asserts executive privilege before a committee of Congress. So in other words, they present as the law what are actually the office's legal conclusions. Similarly, much of the historical practice in this area is contested, just as the law is unsettled. But you never know about this uncertainty from reading the memos themselves. Instead, they nearly always characterize their conclusions as sort of what the law is, as Justice John Marshall might say. And it may be true as a practical matter that within the executive branch, it is the same as law, but they don't contain any caveats limiting the memo scope to that intra-executive context. Another phenomenon that contributes here is that once the OLC stakes out a legal position, its characterization of the law tends to become more and more definitive over time. One former OLC lawyer has called this a pro-executive drift. And this is what happened with the memos regarding whether presidential advisors have immunity from testifying before Congress. So if you look at the first memos on this issue that were drafted in the 1970s, the conclusions that came out of them were described as tentative or very fact-specific. But over time, the memos have sort of lost those caveats. And to support the definitive statements about presidential advisors' immunity from testifying, the memos often include long string cites to nothing but earlier executive branch memos. And in fact, when it comes to the immunity from testimony for presidential advisors, OLC has persisted in this definitive statement of the law, even after several district courts have rejected that position. Now, a consistent executive branch practice might, in fact, provide a basis for legal argument that practice has become accepted if Congress has acquiesced in the OLC's view. But again, using testimonial immunity as an example, by continuing to subpoena presidential advisors, Congress has clearly indicated that it does not accept the premise that they are immune from legislative process. Nevertheless, that continues to be OLC's position. So I've got two more effects here that they'll be quick, and then we can move on to potential remedies. So the third mechanism is that by providing support for the executive's position by casting it as legally based and consistent with longstanding practice and policy, OLC opinions lower the political costs of non-cooperation. So the existence of a memo allows the president to argue, I'm not being obstructionist, I am just following the longstanding policies of the executive branch. This is how we have always done this. So they make that argument even when the law that is cited derives solely from past OLC opinions, and even if historical evidence is conflicting or contested or inconclusive. And here is where, or one area at least, where OLC's reputation for independent analysis is really critical. If the president is just following the advice of his widely respected, impartial Justice Department advisors, then it really minimizes Congress's assertions to the contrary, and it can be characterized as congressional overreaching. Finally, I think these memos discourage compromise. They set the executive's sort of original bargaining position, and they discourage the president from compromising, even if a particular president might prefer to do so in a given conflict. So again, the OLC views itself as a guardian of executive prerogatives. And so it'll often argue against allowing a particular administration or an individual president to compromise for fear of weakening the executive as an institution. So for example, OLC notes that allowing president's close advisors to testify before Congress creates the impression that, quote, such testimony is a matter of legislative right, not executive grace, and that yielding once tends to ultimately produce subsequent, more frequent, more vigorous demands. So it actively discourages negotiated compromise on particular issues where OLC wants to preserve presidential prerogatives. So in all these ways, OLC's memos advantage the executive, making it more difficult for Congress to access the information than it otherwise would be. You know, again, this is not to say that these memos are outcome determinative. The role of partisanship is obviously enormous in these situations, and whether the president and one House of Congress are from the same political party or not is going to be a major factor. And there even might be times where under divided government, there's sufficiently strong public pressure for disclosure that it can force the executive to comply with congressional requests, even in the absence of an OLC memo. But at the margins, I think Congress is at a disadvantage. Okay, so what to do about that? So there are sort of several different angles from which I thought about approaching the problem. So one might be to look for executive branch-based solutions. So for example, OLC's mission could be reconceived, or at least in the context of separation of powers issues, to play a more independent role, to act more like an independent judge than like an entity inside the executive branch. So that's one option. Another option might be to require dissenting opinions in separation of powers memos, forcing the office to acknowledge and confront the arguments on Congress's side of the issue in a very explicit fashion. And some memos acknowledge counter arguments, but they tend to be pretty dismissive of them. The perceived failings of the Trump OLC to live up to the office's aspiration as a sort of apolitical entity have prompted some discussion of possible OLC reforms. There's a recent American Constitution Society project on OLC and the rule of law that has recommended revisiting a Clinton-era memo written by former head of OLC, Walter Dellinger, that discusses general separation of powers principles. And in particular, the idea is not only could this memo be updated to take into account intervening Supreme Court decisions, particularly when it comes to appointments, but it could also identify and correct for that sort of pro-executive drift that I mentioned, and recommit the office to really paying attention to the prerogatives of co-equal branches of government. Now, I think that that kind of internal effort is certainly worthwhile and might undo some of the most egregious examples of the executive's refusal to cooperate with congressional oversight. But I don't think it's likely to address all of the concerns I raise here, because arguably the phenomenon that I'm talking about is not a flaw in OLC, that maybe OLC is operating exactly as it should, but rather a failure on the legislative side to respond effectively. So it might make more sense to look to solutions that come from inside the legislature itself. One thing that's sort of the low-hanging fruit of recommendations here would be to create a similar office within Congress, an office of Congressional Counsel. And in fact, a recent incident sort of illustrates the potential impact of an office like that. So you might recall in January 2020, in the midst of the controversy over the president's phone call with the Ukrainian president, the GAO issued a finding that President Trump's withholding of military aid from the Ukraine violated the law. And the GAO's legal position provided a significant legal argument in Congress's favor and had quite a meaningful impact on public debate. But this is more the exception than the rule, and there are quite a few obstacles to the creation of an independent Office of Congressional Counsel, and I'm happy to talk about some of those in Q&A if folks are interested. Another option would be to sort of build on that GAO example and develop something similar within an existing institution. So maybe the GAO, maybe the Congressional Research Service. The Congressional Research Service already does issue reports on these kinds of issues. It tends to do so, though, in a very sort of descriptive and neutral manner. So one possibility would be for that office or a division of that office to shift its approach to more closely resemble that of OLC and sort of shift a bit more toward a pro-congressional perspective on these unsettled questions. A less aggressive approach that I think nevertheless would be quite helpful and would be quite helpful to me as a researcher as well, would be for Congress to create a document clearinghouse of legislative arguments in separation of powers disputes. So it's not that Congress hasn't made counter arguments against OLC, but those arguments tend to be buried in committee reports or legal briefs or correspondence between committee chairs and the executive. And surely there are internal memos in many legislative and committee offices advocating pro-congressional positions that have just never even seen the light of day at all. So one of OLC's great strengths, is its database of precedent, which helps it to frame the debate and provides a sort of pedigree for the legal opinion at issue. That it provides the argument of, this is how this issue has always been viewed. So I think it would be really useful for Congress to be able to point to something similar. Then there are reforms that come from neither executive or legislative branches or from both. And one thought that I had is that it might be helpful for more government employees to be detailed across branches of government. So usually when one employee is detailed to a different part of the government, it's within the same branch of government. So someone at Maine Justice might be detailed to one of the US Attorney's offices for a time. But sort of sociological literature has shown that detailed employees are able to acquire an understanding of their assigned institutions' norms and culture and objectives, and that these characteristics tend to become internalized. And so based on that phenomenon, there have already been scholars who have called for sort of specific uses of details. One in particular is, some people have said OLC lawyers should be detailed to the State Department's Office of Legal Counsel to provide them with more perspective on the role of international law, because that often seems to get short shrift in OLC opinions. So an OLC attorney who's detailed for a time to a legislative committee might develop a different perspective on competing constitutional interests surrounding congressional access to information. Again, it's not perfect. Those attorneys tend to be in their jobs, turnover tends to be relatively quick. So as an institutional matter, that may not be entirely ideal. Nevertheless, it's a possibility. And then finally, just quickly, a brief word on remedies in which I don't have a lot of confidence, and that is the courts. So some argue for a more active role for the courts as a solution, that courts should step in and decide these disputes. And I definitely agree that that mechanism should be available. And in the Protecting Our Democracy Act, the bill that's been introduced by the Democrats, sort of wish list for structural reforms, that includes measures that would really improve on the status quo and would expedite the process in a lot of ways. But even if those reforms were enacted, a world in which Congress's primary mechanism for securing information requires litigation, it's just not ideal. It doesn't lead to the kind of cooperative problem solving that we would much rather see go on between the political branches, as opposed to a sort of litigation, zero-sum game attitude. So while I would welcome a more effective mechanism for seeking judicial resolutions, I don't think that kind of reform obviates the need to address the effective OLC opinions as well. So the ACS project on reforming OLC, the Protecting Our Democracy Act, I think those efforts sort of indicate that we're at a sort of inflection point. We're in a moment where the last executive's attitude about oversight was so out of line with any sense of propriety that it seems like there's going to be some inevitable rebalancing of congressional executive prerogatives, at least a little bit, in Congress's favor. At the very least, I suspect Joe Biden is not going to publicly announce that he will fight all congressional subpoenas. And so I think that as part of the opportunity that this moment represents, where so many people are rethinking so many aspects of executive oversight, I think that the role of OLC opinion should form a part of that conversation. So I'll conclude there. Thanks again to the Levin Center, and thank you for listening. And I look forward to questions.
Professor Berman, thank you so much for that excellent presentation. And it's obviously spurred a lot of interest because we have a lot of people watching and we have quite a few questions that have come in, and I'm going to try to get to these quickly and efficiently. And I'm going to try to take them sort of in the order they've come in. We received a question about what you identify as the independent but not impartial analysis of the Office of Legal Counsel. Question is, how would you compare that to the Solicitor General's office, and how that same kind of dynamic of being independent but not impartial has varied across administrations? How would you compare those two?
Yeah, I mean, I think as a litigation, I think any office that's involved in litigation is likely to be, the tendency is going to be to take an advocacy position. With the Office of Legal Counsel, I think, so one thing I didn't mention in the talk is that the separation of powers opinions that they issue is only a part of the work that they do, of course, right? So there's a lot of opinions that they issue, does the FDA have jurisdiction to regulate vaccines or something like that? And so there really isn't the concern, there's no really pro-executive position necessarily on those kinds of issues. And so I guess in my view, ideally, the office would treat their separation of powers issues in the same way that they treat those truly non-separation of power, like what the FDA does is not so much going to impact what Congress does directly. But I think it's entirely appropriate for the Justice Department, the Civil Division, the Solicitor General's office to take a position that is consistent with the administration's view of the law, and we see those positions change as administrations change much more often, I think, than we see with OLC opinions.
Mm-hmm. I want to get to as many questions as I can here. Another question that came up early here is, in past, it was the practice that Office of Legal Counsel lawyers would have to appear before Congress to defend their legal opinions. Has that? Do you know whether that's been occurring in recent years, and sort of what has happened to that practice?
Yeah, I am not aware of that having happened in recent years, and the head of OLC is a political appointee, and so it may be that people have appeared as sort of part of that process of putting political appointees in place. But I am not aware of lawyers from that office having to go to Capitol Hill and defend their work, which I think would be fabulous, because at the very least it would require Congress to sort of articulate an argument against them, which I think is often lacking. Mm-hmm.
One of the things that this is another question from the audience, and one of the things that's been observed is that in many cases, positions in the OLC have been stepping stones to other positions, particularly judgeships. And that's added to the influence of the office, because these folks then go on to very influential positions in the judiciary. Aside from creating a new office or clearinghouse in Congress or in the legislative branch, what would it take for Congress or any legislature to be seen similarly as sort of a stepping stone to that sort of prestigious legal position?
Yeah, I mean, it would take time, that kind of office culture is not something that you can create by fiat. And an OLC has really self-consciously tried to cultivate that. And it's a really great, interesting job. And so they get a lot of fantastic candidates. But I think the job would be similarly interesting on the congressional side. And I think it would, it would just take some time for the alumni to sort of establish a record of success the way that OLC alums have.
Another question, have you considered the effect of the Office of Legal Counsel being in the DOJ as opposed to being its own, independent agency or, elsewhere in the executive?
Yeah, I have thought about that. Obviously, that's one way to try to make it a more independent entity, but this at least the way it's structured now is that the OLC is the office to which the Attorney General has delegated his authority to provide legal interpretations for the executive branch. So I think it would have to be sort of, unless the Attorney General was willing to sort of get rid of that particular institution, maybe there would have to be an additional office outside the Justice Department. But I don't see the Attorney General's responsibility to provide legal opinions disappearing, and that's the role that OLC.
So you'd have to have a second office in some other entity.
I think so.
Right. Another question deals with the existing Senate Office of Legal Counsel and the House, the House's Office of General Counsel. Could you comment on issues that have arisen in Congress executive branch disputes and sort of differences between the positions taken by those two offices?
Yeah, so the way that I see those offices is more like sort of the DOJ Civil Division. What they tend to be involved in litigation, and as I think the question implies, they aren't necessarily bound by the views of the other or even by their own past views. And that's one of the challenges of creating this kind of institution within Congress, is it's not a hierarchical entity with someone at the top who can say, who makes the rules. But I do think that I guess that's another place where you could locate this kind of office as, sort of a joint Senate, House, as part of those offices, and that would play a different role. But I think right now they tend to be much more focused on like responding to events and litigation of specific details.
Another question that's come up is that we have a judiciary that is arguably too pro-executive in its view of constitutional jurisprudence. Do you think we need judges and lawyers, who have been lawyers in the legislative branch who bring that experience to the judiciary?
Absolutely. Just like I think we need public defenders as well as prosecutors that bring that experience to the judiciary. One of the things that I mentioned in the paper that I didn't talk about is sort of once these memos come out and the way that they get sort of disseminated through the media and through sort of legal elite echo chambers, if you look at who is commenting on CNN or widely read blogs, they're all executive branch former employees. There are very few former congressional employees that play that role of sort of legal analyst in the media. So I think yes to that idea for the judiciary, but I think the media could also diversify in that way as well.
Right. Now, you laid out a number of options, obviously, in your remedies, for what the House and Senate might do in terms of creating some sort of office of legal counsel, or whether it could be, located in a legislative service organization. You talked about some barriers, particularly around CRS or GAO, creating, doing that within those two entities. Could you elaborate on that a bit?
Well, I mean, it would change their mission to a certain degree. You know, they serve a particular purpose. Well, GAO, first of all, I think their the scope of their authority is much more limited to. I don't pretend to be an expert on, you know, GAO's mandate, but I think it has to be related to money in some way, appropriations. CRS is much more, you know, broadly focused. But again, their role is really informative. It's not argumentative. Occasionally you'll get some opinionated views in there. But I think in some ways the barriers there are similar to the ones in, you know, the House and Senate counsel's office or creating an independent office, which is if Congress wants to have an entity that does this, they're going to have to get together and they're going to have to agree that that's what they want, and that at least there's going to be a presumption that that position is Congress's position. And I think that might be the downfall of sort of any of those efforts.
We have a question from the audience about the GAO Appropriations Law Red Book, which the GAO General Counsel relies on. Could you comment on that?
I cannot, because I do not know what it is. Reinforcing my statement that I am not an expert on the GAO,
Okay.
but I will certainly investigate.
I probably shouldn't have asked that question after you said that. I apologize.
It's okay.
So we obviously, it looks like, you know, nobody has a crystal ball here, but Merrick Garland, you know, has been nominated to be the next Attorney General. And, you know, there's going to be an expectation or potentially an expectation that he, you know, would be looked to review and repeal some of the OLC opinions issued by the Trump administration. What are your thoughts about that?
Yeah, I certainly would expect there to be at least a review. I don't think we've heard yet who is proposed to lead that office, but it's certainly something that President Obama did when he came in after President Bush, and he rescinded multiple memos that had come out of that office and reissued replacements. So it's not something that happens often. It's not something that the office does lightly. But I do think we're at another point, sort of the way we were in the early Obama years, that there's a sense that it's gone off the rails, at least in some instances, and that those need to be reviewed. And so I would expect that to be part of Merrick Garland's very large job.
Would you include in that list of opinions the you know, the Congress has no standing to enforce a congressional subpoena, and the, you know, presidential aides are absolutely immune from congressional subpoenas? Would those be two that you would?
I mean, I personally think that those need to be looked into. Like I said, the initial conclusion about them was very tentative, and it's just been sort of run with for 50 years. But again, those are some of the most longstanding positions that have been maintained across multiple administrations. I think the presidential advisor's immunity one might be ripe for review because it's been rejected by the courts, by not the Supreme Court, but it's been rejected in the district court multiple times now. And I think the office needs to take that into account. But I also think that there are other sort of low-hanging fruit, like I think the office justifying withholding the president's tax returns, for example, is one that people point to as just very weakly reasoned.
We have a question from the audience that really asks sort of a broader question about, you know, in recent years, we've just seen Congress not have a willingness to stand up for its institutional prerogatives. And there have been so many instances, you know, where Congress has just backed the president rather than look to preserve its interests. Do you see that changing? Do you think we've got a moment here, or we're entering potentially a new era when Congress might shift toward reestablishing or reasserting its prerogatives?
I mean, I would like to think so. And I think, Republicans are probably going to be much more interested in exercising strong oversight over a Biden administration than they were over a Trump administration. And so maybe that will create the sort of bipartisan desire for change that actually goes somewhere.
Mm-hmm.
But I feel like just in so many ways, Congress has not been a profile in courage. I don't really, I don't have high hopes that they will stand up and do the right thing for the institutional integrity of Congress. That just doesn't seem to be what most of them are interested in.
Mm-hmm. So, and we're running out of time. So we're getting sort of to our final question. Sort of the bigger picture. You're proposing, a system where there would be these, two entities at least, issuing opinions that relate, from the legislative side and obviously from the executive side, issuing opinions on these critical issues related to legislative authority and oversight. How do you think that might change the debate if Congress has this, an entity that is issuing these opinions, cloaked in sort of more legal credibility?
Yeah, I mean, I think it would provide sort of a counterweight. Like in many ways, I think OLC is out there and there's nothing coming from the legislative side to refute the legal arguments, or if it is, it's statements by individual members. So I think making it more of a public discussion of two sort of equally plausible arguments, as opposed to sort of one heavy hitter and individual legislators trying to push back against that institution.
Right. Well, Professor Berman, thank you so much. We have now come to the end of our time. This was really a terrific conversation, and your paper is fantastic.
Thank you.
We just so value this work, and we value the input that we're getting from many other scholars who are joining us on our Oversight Scholars listserv, as well as in other fora. I do want to mention here at the end that the Levin Center, had the opportunity in 2020 to present before the House Select Committee on Modernization of Congress, and we urge that there be created an Office of Legal Counsel that would represent Congress in these kinds of disputes. We really think it would help, these committees, individual members of Congress, and just the institution as a whole be more effective in everything they're trying to do, particularly in oversight. Professor Berman's paper really offers a taste of many, many fascinating issues that we believe we can get into in reviewing oversight and thinking critically about issues that are raised by congressional oversight as well as state legislative oversight. So we encourage everyone who's listening, particularly people who are scholars in this area, experts in this area, to submit your own paper in the future. The deadline for submitting the 2021 paper for the 2021 Levin Center Oversight Research Award is November of 2021, and the cash award for that will be $2,500. So we hope that's a strong incentive to everyone to help us in this very, very important work, and it is certainly something that we will value and make sure we let the world know about. The recording of this conversation will be posted on our website as soon as possible. And with that, I want to thank everybody for listening and watching, and we look forward to working with all of you in the very near future. Thank you so much.